Hello, everyone. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip on Facebook, and here on YouTube as Justice with Jax. Sorry, I skipped last week's Wednesday at 1 Central because I was just lazy. No excuse. Just lazy. So what we're going to cover today is Stephen Avery wrote a letter that he addresses to Wisconsin legislature. And I have not read it yet. I've just been waiting to read it when I go live with y'all. So I've put the link in both the chat and in the description for this live, so you can click to read it for yourself. Sup, Cat? And hello, Ashley and Shimpy. So we're just going to read this together, and then I will give whatever comments I want to respond to this. So this was written, I don't know if there's a date on here. We'll have to see if there's a date when it is written. Cool cats and kittens. Hello, Deborah and Andrea. But when it is scanned on here is March 24th. And there are 8 pages of this. And so at the top of this, it says to Wisconsin legislature from Stephen Avery. But then it has handwritten on the right side and says, and I don't know who wrote this. It says, this is addressed to the legislature. Based on that, this should be filed in 05 CF 381 as, quote, submission to legislature, unquote. And then it's initialed. It looks like the initials are RD, unless that's RO. And then that's dated March 29th, 2022. Hello, Millbilly. I'm looking very smart today. Oh, wow. Thank you. So, all right. So it says filing a complaint. The State Commission on Judicial Conduct reprimanded Judge Angela W. Setkowitz for exceeding the scope and authority of her office and for failure to comply with the law. Judge Angela W. Setkowitz, I had scanned this when I first got it a week ago. And so there's a lot of typos and misspellings and such, so clear that this wasn't written by attorneys. So I'm going to read to you as it is written, just so you know. So, all right, Judge Angela W. Setkowitz, she, quote, turned a blind eye to much of the evidence and also refused to admit probative admissible evidence that, when evaluated under the proper standing, is damning, unquote. Judges. So then it says Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. And now Canon 2. A judge shall perform the duties for judicial office impartially, competently, and diligently. Canon 3. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office. Canon 4. A judge or candidate for judicial office shall not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. And then, since we're at the bottom of this page, it is stamped, filed March 24, 2022 by the Clerk of Circuit Court in Manitowoc County. Page 2. So at the top of this page, it is also saying to Wisconsin legislature from Stephen Avery. And then it has date and a line, and on that line is handwritten March 21, 2022. And so then it says again, filing a complaint. Oh, wait, that's the same exact thing, everything that I just read. That's everything I just read. All right, let's go to page 3. Hello, Jen. Jen, I am reading a letter that Stephen filed with the court, the circuit court, on his behalf. So, but so far, the first 2 pages was the same thing over again. So now we have judges behaving badly. Judicial misconduct refers to acts that are unethical, illegal, or in violation of the judicial obligation of impartiality. As we have seen, there are myriad ways. Now, again, remember, I'm just going to read it with typos and grammar stuff. There are myriad ways in which judicial misconduct rears its tainted head. More often than not, I'm going to guess that was supposed to be such misconduct is subtle. Sometimes it is blatant. The 14th Amendment secures the right to due process. The 8th Amendment prohibits the use of cruel and unusual punishment. During an arrest or detention, these rights can be, okay, so this is to be, the word is to be violated, but the T is missing. So violated by the use of for, and for is spelled F-O-R-E. So I don't know if this is supposed to be use of force, maybe, and the C is missing. Use of for amounting to punishment, and then it's got in parentheses summary judgment. The person accused of a crime must be allowed the opportunity to have a trial and should not be subjected to punishment without having was misspelled, but somebody because it was Haveng and somebody put an I over the E, without having been afforded the opportunity of the legal process. Fact. Based evaluation of weight of evidence in a claim. Failure to keep from harm. The public counts on its law enforcement officials to protect local communities. If it's shown that on official, maybe it's supposed to be an official, willfully failed to keep an individual from harm, that official could be violation the color of law statute in the true of justice. Maybe I should have read through this first so I'd understand it better. Reached by actor framed for murder. How important is the question of innocence to a judge? Judes, so I'm going to guess that's supposed to be judges. Judges who rejected over and over his or her claim that he was a victim of police and prosecutorial misconduct, and his exoneration didn't matter to the Wisconsin is spelled wrong, Wisconsin court that rejected his estate's claim for compensation for his wrongful conviction for the second time. Ruled that an attorney rendered ineffective assistance of counsel by not telling me nothing at all. It's not funny, but it is, because it's like I can clearly hear in my head Stephen's voice saying, ruled that an attorney rendered ineffective assistance of counsel by not telling me nothing at all. I mean, it's clear Stephen. Is attorneys Dean A. Strang and Jerome F. Buting. I told them all the evidence back when I had them, and they didn't. And that's how Stephen talks. So, he means the word didn't, but it's spelled dint, but that's how he pronounces it, didn't. They didn't do nothing at all. They keep telling me the state did all of it. If they would have did their job, I won't be in here. If they would have listened to me, they would have won my case for the truth. If they would have investigate my case, but they didn't, dint, didn't do on investigation on my case at all, and that's underlined. And Dean A. Strang and Jerome F. Buting, the lawyers, admits, so it's supposed to be admits, but it has a B instead of a D, admits they were ineffective in Stephen Avery's trial. They mishandling my representation, and now this section is all underlined, regard to discharged juror that they were to have a record in court, and they were sitting in a restaurant eating and drinking liquor, and they told the judge to let the juror, and now it's not underlined, go, and that was against the statute and law, and law. And Bobby's computer and all these Brady violation is underlined, that they didn't do for me. And Dean A. Strang and Jerome F. Buting was working for the DA, Kenneth R. Kratz. They would always spelled with two L's, they would always listen to them and not their client, Stephen Avery. This is underlined now. Dean told Jerome not to tell me nothing. And now it's no longer underlined at all on my case. And that is not their duties for their clients. All right, before I continue, let me speak on that for a second. One, I know there's stuff that Strang and Buting did not tell Stephen about his case, and I'm sure Kathleen Zellner does it as well. And it's actually necessary because Stephen, I'm sure Kathleen didn't know this was going to be filed, and I am sure this annoyed the shit out of Kathleen that this was filed. And so there's going to be things about the case that you would keep from Stephen because he does harm to himself. And so they're not sure if Stephen is going to just blurt stuff out that they don't want out to the public. So they're not going to tell Stephen. So I understand that. But I also understand Stephen's side as well, because this is Stephen's life. Stephen's the one sitting in prison all these years. And you start to feel like you're forgotten about and nobody is doing anything about your case. So you just want to do something because you're feeling like your lawyers aren't doing anything for you. But in reality, it's because our system sucks. I mean, I'm sure I say that every time I do a live on how horrible our criminal justice system is. And all this wait. And I've told you one of our number one questions on Stephen Avery Project, where we have 220,000 people on there, where we get the messages every day. What's new in Stephen's case? Over and over again. What's new in Stephen's case? And then the other one is, when's the next season coming out? Thanks, Nana. Thumbs up for Nana too. So it feels like nothing is being done, but it is just how horrible this system is that it takes years. And Kathleen has said, we go over this every time, Kathleen has said it typically takes 15 years for her to overturn a wrongful conviction. And she's only been on this case since 2016. So them not telling Stephen everything about the case, I'm okay with, but I also understand Stephen's frustration with it. Now, back when I used to talk to Stephen, he told me that he said things about his case that he wanted Strang and Buting to do, and they didn't do it. So that, of course, is your ineffective assistance of counsel, which is standard. Most people, when they're trying to file to get into court again after they've been wrongfully convicted, ineffective assistance of counsel is the go-to thing. And it's not a slam on Strang and Buting, even though I know Stephen hates them both. But it's not a slam on them. I personally feel for Strang and Buting, they were in over their head on this case. You know, this case didn't have the international attention that it has now, and all these eyes that have been going over and over every little morsel on this case. Um, they didn't have the money, they didn't have the time, so they dropped the ball on things. Some is understandable, some is not. I have an issue with Stephen personally told them to get Barb's computer. Get her computer. He told me he told them that. Get Barb's computer. And then right after he told Strang and Buting that, then the state went and took that computer. Who are not supposed to be listening when he's talking to his lawyers. But we already know from stuff that Kratz has said that they were absolutely watching his lawyer meetings. So, so he's right to be upset there because he told them things and they didn't do anything about it. And it has always bothered me that if you're going to play the semantics game with that computer, you know how the Avery family likes to say, it wasn't Bobby's computer, it was a family computer, it wasn't in Bobby's room, even though you can see in the evidence pictures the computer in Bobby's room. So whatever. But, you know, but then when Kratz has it investigated, then what he says to Strang and Buting, there's nothing of importance on Brendan's computer. And Strang and Buting just took that as face value because Brendan wasn't part of Stephen's case. And you're not expecting there to be anything really, to care about on Brendan's computer. And they just listen to Kratz. Oh, not the droid you're looking for. Okay, well, I'm not going to look at this computer. But Stephen told them over and over again, look at this computer. You need to get this computer. And they didn't. So, yeah. All right, next section. Circuit rules abused discretion when they failed to conduct evidentiary hearing on Brady claim and on conflict of interest claim. To establish a Brady violation, a defendant must show 1, the government withheld evidence, which we know they did. 2, the evidence was favorable, ... because ... of impeachment value. Now, in legal briefings, when you have those 3 dots, it means that the actual text is longer, but this is just cherry picking the things that are pertinent to what he's trying to say here. That's why there's the dots. So favorable ... because ... of impeachment value, which we know there was so much evidence that was not used that shows Stephen's innocence. And 3, the withheld evidence was material. For evidence to be material, it requires only that there is a reasonable probability, spelled incorrectly, the outcome of the proceedings would have been different if the evidence had been disclosed. Wonder who helped Stephen with this. I mean, this isn't the first time that Stephen has written a letter to the court. And I know Stephen studies a whole lot. I mean, because you got nothing but time and, you've got law books available to you. I couldn't write something like this up, but I, even though I report on these cases, I'm not the person who tries to pretend to be a lawyer. I, I'm not a professional in any of that. But I'm sure Stephen had somebody else in prison help him, because there are a lot of people in prison who then will help each other. But and when I'm telling you that there's misspellings or grammar mistakes, it's not to try and look down on Stephen, because I couldn't have written this. It's just so you can get the overall feel of it. But yeah, it gives me a little smile of Stephen being able to put something like this out, even though I'm sure Kathleen is having a fit. Okay, back to it. Because only the prosecution alone can know what was undisclosed, a petitioner need only make a prima facie. I don't know what that one, I don't know what that legal term is supposed to be. Prima facie. Facie is spelled Facie. Showing of a Brady violation in order to obtain an evidentiary hearing. A lower court abuses its discretion when it denies an evidentiary hearing after the prima facie showing has been made, and the claim is not otherwise procedurally barred, or if the factual allegations are not contravened by the existing record. Circuit Court erred when it failed to convene an Okay, this has just a typo. It's supposed to be evidentiary, but there's a C instead of a V. Convene an evidentiary hearing. A petitioner claiming a conflict of interest must prove 1. Multiple representation that 2. Created an actual conflict of interest that 3. Adversely affected the lawyer's performance. Claim by showing that attorney failed to pursue an alternative strategy that A, could benefit the instant defendant, and B, would violate the attorney's duties to the client. Now we're on page 5 of 9. So this is judges or justices and judges and municipal judges. Oath of office, ineligibility to other office, salary, conservators of peace. 1. Every person elected or appointed justice of the Supreme Court, judge of the Court of Appeals, judge of the Circuit Court, or municipal judge shall take, subscribe, and file the following oath. State of Wisconsin, count of ... I, the undersigned, who have been elected or appointed to the office of ... And now this next section is underlined. But have not yet entered upon the duties thereof, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Wisconsin, that I will administer justice without respect to persons, and will faithfully and impartially discharge the duties of said office of the best of my ability, so help me God. Done being underlined. 2. The judge of any court of record in this state shall be ineligible to hold any office of public trust except a judicial office during the term for which he or she was elected or appointed. 3. The judges of such courts shall be conservators of the peace and have power to administer oaths and take the acknowledgments of deeds and other written instruments throughout the state. Next section is titled Powers of Courts. The several courts of record of this state shall have power to administer oaths to witnesses in any such matter or cause, and in all other cases where it may be necessary in the exercise of the powers and duties of such court. 3. To devise and make such writs and proceedings as may be necessary to carry into effect the power and jurisdiction possessed by them. 4. To exercise any of the power and duties of a circuit court commissioner. Next section is titled Substitution of Judge. 2. When the clerk receives a request for substitution, the clerk shall immediately contact the judge whose substitution has been requested for a determination of whether the request was made timely and in proper form. If the request is found to timely and in proper form, the judge named in the request has no further jurisdiction, and the clerk shall request, spelled incorrectly, the assignment of another judge under statute blah blah blah. If the judge named in the substitution request finds that the request was not timely and in proper form, next section is underlined, that determination may be reviewed by the chief judge of the Judicial Administrative District. If the judge named in the request is the chief judge, if the party who made the, and now not underlined, substitution request files a written request for review with the clerk no later than 10 days after the determination by the judge named in the request. If no determination is made by the judge named in the request within 7 days, next section underlined, the clerk shall refer the matter to the chief judge of Judicial Administrative District or to the chief judge of an adjoining Judicial Administrative District, done underline. If the judge named in the request is the chief judge, for determination of whether the request was made timely, spelled incorrectly, and in proper form and reassignment as necessary, the newly assigned judge shall proceed under statute blah blah. If you're lost, don't worry. I am too, with a lot of legal gobbledygook. Manitowoc County Circuit Court took me out of my jurisdiction and my district for the substitution of judge, and I do have 3 judge in my county, and I should have staying in my own jurisdiction in my own district. And I should had a hearing on this motion at that time when I put this in. The case number is blah, blah, blah. And they gave me Honorable Judge Angela Setkowitz, judge presiding from Sheboygan, Wisconsin, and I should have to stay in Manitowoc County, not in Sheboygan. I agree. Legislative findings, 2007, Wisconsin Act 1. The legislature finds that providing under 2007 Wisconsin Act 1 for the place of trial in the county where the offender resides is consistent with the legislator's authority under Article 1, Section 7 of the Constitution and with previous acts by the legislature providing for the place of trial in countries other, now this is underlined, than where the elements of the offense may have occurred, done underline. The legislature further finds that allowing defendants charged with violating offenses covered by 2007 Wisconsin Act 1 to, now this is underlined, request a trial in the county where the offense occurred, done being underlined, is consistent with the protections in Article 1, Section 7 of the Constitution. The legislature finds that violations of offenses covered by 2007 Wisconsin Act 1 are violations of the public trust, spelled wrong, that should be adjudicated. So trust is missing the U, but adjudicated is spelled correctly. In the county where the offender resides, so the individuals who the defendant interacts with daily, serves, or represents as a public official or candidate, and whose trust was violated by the offense, will judge the defendant's guilt or innocence. The legislature further finds that to so provide is consistent with equal protection of the laws under Article 1, Section 1 of the Constitution. The legislature finds the venue provision in 2007 Wisconsin Act 1 represents an appropriate balance between the rights of the defendant and the need to prevent and prosecute civil and criminal offenses covered by 2007 Wisconsin Act 1. So that is, he's complaining that he should have been kept in Manitowoc. Now, whether or not that's factual or not, I don't know if he had a different judge, if anything would be different for him. But you play all the cards you can, though. And, you know, we would really like to get rid of Setkowitz as something shady in there. All right, next section. I should had a new trial on all the new evidence. The circuit court abused its discretion in summarily dismissing Mr. Avery's second motion pursuant to Wisconsin statute, blah, blah, without addressing the 5 Brady claims raised and in subsequently denying Mr. Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution. A, standard of review. B, Brady violation regarding Mr. Romlo. C, Brady violation regarding Mr. Redant. D, Brady violation regarding original flyover video taken on November 4, 2005. E, Brady violation regarding zipper voicemail. F, Brady violation regarding Ms. Heidel. G, Brady violation regarding Dassey Yonda CD computer that Bobby Dassey was using, and it had all this, and now this is all underlined here. This huge section underlined. All this stuff on it to access violent images of young deceased females, rape, torture, incest, and pedophilia on the internet at times when only Bobby was home. And he had a picture of Teresa Halbach and Stephen Avery, and this looks like a good suspected to the case. And the new eyewitness, Thomas Sawinski. Mr. Sawinski was a motor route driver for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed 2 individuals, a shirtly Bobby Dassey, and then it's got in quotes in parentheses Bobby, as all legal stuff does, that it's no longer going to refer to him as Bobby Dassey. It'll just be Bobby from here on out. And an unidentified older male suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. After Mr. Sawinski drove by Bobby and the under individual, and is all capitalized, delivered the papers to the Avery mailbox, he turned around and drove back towards the exit. When he reached the RAV4, Bobby attempted to step in front of his car to block him from leaving the property. Mr. Sawinski was within 5 feet of Bobby, and his headlights were, missing an E, on Bobby during this entire time. Mr. Sawinski swerved into a shallow ditch, which Carla claims there's no ditch, and there is, to escape Bobby and exit the missing a Y, property. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day on November 5, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office and spoke to a female officer, reporting everything. Everything had an O, but an I is written over it. He has stated in this affidavit. This was the 8th Brady violation the state held. The Brady number 7, and now it's not, well, this is underlined because it's for this subject. The Brady number 7 of a violation of due process and destroyed evidence, now not underlined any longer. The issue on remand to the circuit court was whether the state violated Youngblood versus Arizona and Wisconsin statute, blah, blah, when it returned the human bones to the Halbach family in 2011 without giving notice to Mr. Avery or his counsel. Mr. Avery's supplemental motion alleged material facts sufficient to establish a violation of the Wisconsin Evidence Preservation Statute, Wisconsin Statute, blah, blah, and Youngblood. Because the statute does not provide a remedy for convicted persons in the event of a violation, fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. Mr. Avery's supplemental motion contains sufficient material facts for the circuit court to fashion a remedy for such, and supposed to be such, evidence preservation violations controlled by United States Supreme Court precedent addressing evidence preservation violations. See California versus blah, blah, Youngblood, blah, blah, different cases. Taken together, Trombetta and Youngblood comprise the line of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of evidence was a violation of due process, reverse the defendant's conviction. The Due Process Clause of the 14th Amendment to the United States Constitution imposes a duty on the state to preserve exculpatory evidence. Failure to preserve evidence violates a defendant's due process rights if police, 1, fail to preserve evidence that is apparently exculpatory, or 2, acted in bad faith by failing to preserve evidence that is potentially exculpatory. And then it lists another case. Before I go into his last paragraph, let me comment on that. So it's the law that as long as somebody is incarcerated, you have to keep the evidence in evidence because, science is constantly changing. DNA has been such a huge deal in freeing the wrongfully convicted. You need to keep the evidence in evidence, period. And if something is going to be done to any of that evidence, Stephen and his attorneys need to be told and need to agree to whatever is going to happen to this. Then you've got when Kathleen came on board, she had the deal with them that they were supposed to give her these bones. And then they were just playing around with it and ignoring her and such. These are the bones that were found at the quarry. So according to Sweaty Sweat Ken Kratz's whole case, is Stephen never left the salvage yard. So for there to be burned bones in the quarry, if that's Teresa Halbach, then the state's case falls apart. Because how are Teresa's bones over there when Stephen has never left the salvage yard? So these bones were put into evidence. And then when you look at the evidence logs, they gave these bones to the Halbach family like it's Teresa. But you stated when you prosecuted Stephen in court that that wasn't Teresa, that you didn't even know if those bones were human. Because Stephen never left the salvage yard. But you gave those bones to the Halbach family that the state will try and say now of going, why, when asked, why would you do that? Closure? Why would it be closure? Why would it be closure if that's not Teresa? Your own case says Stephen never left. Also, legally, you're not allowed to just get rid of evidence. And you're not allowed to do anything with Stephen's evidence without Stephen's knowledge or consent. You did all those things. And so these bones were given to a funeral home. And where did my thing go? It's over here. Sorry, a pop-up just came up on my screen wanting me to do an antivirus thing. Okay. So, so this is given to the Halbach family to do with what they want. Did they put them with the other alleged bones that they're claiming are Teresa, and we still don't have any proof that the original bones are Teresa either? So now you've tainted the evidence and broken the chain of custody. Because even if these bones are put in a box and buried at the cemetery, it's now commingled with these other bones. So, and these bones were given to the Halbach family, what is it, 7 years later? It's all very suspicious. All right, so his last section here says an evidence-based criminal justice, exclamation point. The criminal justice system is broken and it has to be fixed. And this is the time to fix it and get it right, because I'm a victim of a setup and it has to be fixed now. And then it said it was sending it to Judge Angela W. Setkowitz in Sheboygan, Manitowoc, Clerk of Courts. Sincerely, Stephen Avery, 3/21/2022. And that's the end of this letter. So I haven't heard anything from Kathleen Zellner. You know, she hasn't tweeted anything about this. So I don't know if she would prefer that nobody's talking about this. I don't know, you know, because he did this without her her knowledge or consent, I'm pretty sure. And oh yeah, absolutely, Kat. He's not wrong that the justice system is broken. Everything that Stephen cited in here, just one of those should be enough to get him a new trial. Now, in my opinion, everything's right there to just let him go. He's innocent. There's so much to show what Manitowoc and Calumet and the judges and everybody has done. Big Hair, Sherry Culhane, everybody conspired to put Stephen Avery away. We all know it is also because of his wrongful conviction lawsuit of $36 million. That's why the fix was in. I personally believe lower cops, Peg Lagenschlager, yeah, Millbilly. I feel the lower cops, the ones that weren't around or affiliated at all with the first one, I'm sure there's going to be people who thought Stephen was guilty. I believe that Ryan Hilgas and Scott Blodorn and the Halbach brother, I believe they were told by law enforcement that due to this other case, Stephen's going to walk, and that we know he's guilty, but he's going to walk because of this, and because, you know, he's currently having depositions with some of the officers, the sheriffs and deputies. And so those three helped with whatever, because there were people who were, they believed they were framing a guilty man. I believe. And maybe at that time, if I was part of it, maybe I wouldn't be mad at that. Maybe. I don't know. But in all the years since, after you've seen Making a Murderer, which please don't tell me any guilters who watch this or whatever, that, oh, the documentary is just a one-sided blah, blah, blah. No, it's not. It gives you everything in there. Well, it doesn't give you everything because it's only how many hours. They can't include every little detail about this case in a 10-episode documentary. But when you start looking into the other evidence, there's just even more so that proves Stephen's innocence and that something corrupt was going on in Manitowoc. Yeah, why Lauren says, why is he still not out of jail? Because of a corrupt system and that thin blue line that's going to do everything it can to protect each other. So they would rather let an innocent person rot away in prison than to go against one of their own brothers. Millbilly says Uyghur kept an eye on whom was allowed on property regarding scheduled shifts to keep same law enforcement there. Which this is still out from, where is it? From the last time I did a live. That's visitation list. Oh, of course, it's last thing. So this is the log. I mean, I know it's very professional of who was going in and out of an alleged active crime scene, who is going in and out of the salvage yard. And you can go to StephenAveryCase.org where all these documents are and look at these things for yourself on the people that were going in and out of this active crime scene in early November and see how many times Ryan Hilgas, Scott Blodorn, and Mike Halbach were going in and out of the salvage yard. Why? Why are they going in and out? And tons of Halbachs. Gary Halbach, Debbie Halbach, Brian Halbach, Lori Halbach, Dennis Halbach. Why are these people going in and out and in and out and in and out? And there's also one where Mike Halbach puts a fake name down, going in and out of this crime scene, that they wouldn't let Dolores Avery go get her medication, but you're letting the Halbach family go in and out on November 7th. Brian and Laura Halbach again, Dennis Halbach, Nancy Halbach. Here's Nancy Halbach again. Lots of Joes and lots of Otts. Why are these people in and out of this crime scene? Millbilly says Bushman signs in on 11/7, never signs out, but signs back in. Yeah, there's multiple of those. And they try to use an excuse of, oh, well, so like for Lank, there's one that you see him sign out, but he had never signed in. Well, he got there before they started, this nice professional log thing. That's just handwritten on a piece of paper. Are you not professionals here? It's ridiculous. Sue says, watching the series just pissed me off. This man had been charged twice for crimes he didn't commit. This is the most blatant cover-up I have ever seen. The corruption is unbelievable. It's totally disgusting on what has happened to Stephen. And it's not about how you feel about Stephen personally. When you look at the evidence, take out who the people are. Everything shows that Stephen was framed for this. And there are so many things that, and Stephen cites a whole lot of it in here. Because like Thomas Sawinski, who was one of the most recent people to come forward. Now, recent, I guess technically he's a reasoned person, but he came forward back then and reported what he saw, that he saw Bobby Dassey pushing that RAV4 to the salvage yard, and they did nothing with it. There were people, several different people, that reported that they saw the RAV4 parked by the dam at the turnaround. All that got covered up. No different than when Colborne worked at the jail, the prison, whatever, and got the call saying from a cop that you have the wrong person in there for the Penny Bernstein case. And that disappeared. And he doesn't write a report on it until years later. There is too much that proves Stephen's innocence. And at the bottom, at the very least, it should have been reasonable doubt. But you're not going to get reasonable doubt when you fix his jury as well and have not one, but two people who were affiliated with the Manitowoc County Sheriff's Department on his jury. One being Carl Wardman, who, even when you go to Kathleen's website and click on her Stephen Avery page, the picture at the top of Stephen in the orange jumpsuit, and there's a female officer on one side of him and a male officer on the other. When you look at his name tag, it's Wardman. His dad, Carl Wardman, who was also a community service officer for Manitowoc, that you can Google him and you can see him in a picture with a Manitowoc community service car, is on Stephen's jury, who it's been reported was a total dick and was pushing people to say guilty. And then there was a second juror who was married to a sheriff or a deputy. There was no way Stephen was going to get anything other than a hung jury when you've got two people from the Manitowoc County Sheriff's Department on the jury. And sad for Stephen that they were able to bully people into all saying guilty. It's just really sad. After what they did to Stephen for the Penny Bernstein case, where he lost everything. Lost his wife, lost his children, lost all those years with his mom, lost his, of course, his freedom. He was just 22 years old. This is just such a miscarriage of justice, but it happens all the time. Just like Stephen says, poor people lose all the time. And everybody is protecting this narrative. There are so many people in Manitowoc or who have left, maybe retired to Arizona. They know Stephen's innocent. They know who put the magic key and the shell casing and the car and the blood, because every single piece of evidence they have against Stephen, there's something shady with it. It's not me just being a tinfoil hat person, conspiracy theorist, and gonna find, make up crap for everything, because I go by science and the facts. There is nothing concrete pointing at Stephen. And actually, everything points away from him and at Bobby Dassey. It's a tragedy. And then, of course, the worst thing ever, the thing that I really didn't want to happen, happened in that Stephen lost his mother last year. So now, whenever he is finally able to go free, he doesn't get to spend any time with his mom. And his family took away the last year of her life from Stephen and wouldn't let him talk to her. They even were keeping from him where she was, and they were suing him. Exactly, Kat. No amount of money will ever fill that void. And so now you just got to hope that he can go free while his dad is still there. His dad, I believe, was in worse health than Dolores. And how many times do you hear, when people have been married for so long and are elderly, that when one dies, the other just give up? It really is sad. But, there's many of us out here who believe in Stephen's innocence. Not just believe, I know he's innocent. And he has Kathleen Zellner, who is the best attorney for when you're wrongfully convicted. I know people start to get suspicious and think that Kathleen doesn't care, or Kathleen's left the case, she's busy with Johnny Depp or whatever. She can do more than one case at a time because there's nothing going on with this case currently. It sucks. I don't know how you start to fix our system. It's really sad. Sue saying, I can't believe the Supreme Court would not hear his case. Well, that'll bring me to put my political hat on. We have a primary coming up in June 28th is the primary. And then November is the midterm election. There's lots of people running for judges, all different levels of judges. Here in Illinois, we've got a couple seats open on our Illinois Supreme Court, who you just don't know what's going to happen with judges on the different levels. Because, Brendan's case came here to Chicago to the Seventh Circuit. So it is so important for you to do the research on the people who are running for your state's attorneys, for your coroner, for your judges, for your sheriff. Look into those people and make sure you vote. So you've got Tony Evers, the governor of Wisconsin, who has stated he will not let Brendan go. The guy that was the governor before him said he wasn't going to give clemency to anybody. He's not even going to look at it. So you need to look at how people feel on wrongful convictions. And find the one that is the best option. Maybe none of the ones running are going to be the greatest, but there's got to be one that's better. And, they use these appellate judge, circuit court, all that stuff as a stepping stone to go higher. Or even they'll use, running for your county board or whatever as a stepping stone. Coroner, you don't even have to have a medical degree to run to be coroner. And remember in Stephen's case, Deb, how do you say her name? Catkish? They kept her away from the evidence. That's supposed to be her crime scene. She outranked everybody. But they scared her and she left. You want somebody who is going to stand up for the victim. You want a good coroner. Here in Illinois, the Melissa Kaluzinski case that I never do a live without mentioning Melissa. But when Melissa's case first went to trial, they had doctored x-rays and evidence. And it wasn't until they got a different coroner and he now looked at it. And so then he changed the manner of death from murder to undetermined. The first coroner had said that there was a large crack in the boy's skull and that saw blood. And now when you see the real x-ray, not the one that they doctored and sent to her original lawyers, you see his head looks like a giant light bulb and there's no crack and there's no blood. But because that coroner did that and went against that blue line and said this wasn't true, they went after him. And he can't be coroner now because of it. They took him out. They arrested him. They got him on a stupid election technicality. When you run for office, we've gone over this before, but there might be new people here. When you run for office, you have to have a petition. That's the first step. You have to get a petition and it has to be signed by X amount of people. It varies on how many have to sign a petition. And so say you need 200 signatures on your petition, then you're going to try and get 600, because then the games that get played between the parties is you're going to claim that this one looks fake or this isn't an accurate signature or whatever and toss them out. So you need to cushion it. When petitions are signed, after each page is filled, it has to be notarized by a notary. The person who took that petition around to get the signatures, because the actual candidate does not have to get the signatures. The actual candidate then will just have to sign them all in. But the person who took that petition around and got those signatures has to be present when those sheets are notarized. Okay. Well, in Dr. Rudd's case, the person wasn't there on some of the petitions when they were notarized. And so that's what they used. If it's a simple screw up, not a big deal, whatever, but they went after Dr. Rudd on that, charged him with it. And by charging him with it and prosecuting him on it and finding him guilty on that, it meant that he now can't run for coroner unless he wants to run as an independent. This is why people will run as a Republican or a Democrat, because you don't need to get as many signatures and you don't need as much money to run as a Republican or a Democrat. To run as an independent, you need like twice what the others do. So Dr. Rudd even then offered to, I'll start from scratch and I'll run as an independent and have to get twice as many. And they wouldn't let him. And Dr. Rudd truly cares about what happened to Benjamin Kingham in the Melissa Kaluzinski case. But the corrupt prosecutor, judge, Melissa's judge, and the person who was sheriff are both running. They're running against each other for the Republican to be on the Illinois Supreme Court in this election this year. Remember, I say it's important to look Who's running where and what they're running for? So the sheriff and the judge who put Melissa away, she's wrongfully convicted, been in prison for 13 years now, are running for Illinois Supreme Court. And the sheriff did an article on a Republican website stating that he and Judge Shaines knew Melissa was innocent at the time. But here Melissa still sits in prison. I'm going to visit Melissa on Monday. Melissa is very into her Catholic faith, and so she gave up chocolate for Lent. And so she's very excited for me to come on Monday, and that hopefully if those vending machines are not stocked with chocolate, I'm going to lose my mind, because it's all Melissa's been thinking about since she gave up chocolate for Lent, that she wants chocolate. So, and my mom is so cute. My mom gave me $10. Buy chocolate for Melissa for me. So, because the vending machines and everything have been crap there, hardly filled with anything. So there better be chocolate, because I'm going to be really pissed off if I can't get chocolate from Melissa on Monday. All right. That's today's live. Next Wednesday, will I be live? What will I be covering? Don't know. I'm supposed to do something next week. I have totally dropped the ball on so many different things now that things are starting to, are opened up more, and there's all these in-person events that I missed something I was supposed to be at last night. Now I have to be at something in 2 hours, and I had totally forgotten about it. So it's a good thing that person messaged me. And then I have another event, so I've got 2 events to go to tonight. So I'm having a hard time keeping straight what my calendar is. I really need to start writing stuff down, but I'm so used to, you didn't go anywhere, or anything you did, you were just on Zoom, so, but yeah. So what will I discuss next week? Maybe I'll discuss, Pam Rupp. Is anybody watching that, the truth about Pam, or whatever it is, on regular TV? That's Renee Zellweger. Because next Tuesday night is the finale. So maybe that's what we'll talk about next week, unless something pops up in Stephen's case or Melissa's case. And then I'll probably talk to you too next Wednesday on my visit with Melissa. So watch that, because I'm probably going to want to talk about it and look into that case, or if Stephen's family implodes. Yeah, right. Well, and this is why we also say, make sure you subscribe to this channel and click to like it or whatever, because sometimes I'll go live spur of the moment when something's come out and we've gotten it and I want to discuss it right away, or if there's some kind of drama and I want to talk about. We try and do these Wednesdays at 1 to try and be some consistency, so when to find me live. But you never know when I want to just now pop on and bitch about something, or there's been a filing. So like and subscribe so you can keep track. And we also try and post events and reminders on all of our Facebook pages of when I'm going to go live. So you can look on there too. Yeah, I will absolutely let you know next week if I was able to get chocolate for Melissa, because she's so excited for that. And is this week the final Walking Dead for the next break? So I'll have that to talk to her about on Monday, because, love Walking Dead. And I haven't told her that they've announced another spinoff of The Walking Dead. they're now going to do an Alpha spinoff. So there's going to be Carol and Daryl going off and doing whatever. Then there's Maggie and Negan are going to be in New York. And now there's going to be an Alpha. Sorry for those who don't watch Walking Dead. But Walking Dead is something that's very important to Melissa because it started right when she first got locked up. So she's kind of hoping now too that since Walking Dead is coming to an end, that it'll mean that she's going to get to go home too. So there you go. Stephen's letter to the Wisconsin legislature. If anybody comes across anything on the case and you want me to discuss it, you can send me a message on Facebook, or we've got you can either send it to justicewithjax@gmail.com, or we also have official Stephen Avery project @gmail.com. So send me that. Watch, I think it's called The Thing About Pam. I think it might be on Hulu, that you'd be able to watch all the episodes before next week. And let's talk about that wackadoo. That's a bizarre case. So, all right. Thank you, everybody. Keep your fingers crossed and your toes crossed and everything crossed for Stephen, that we hear something good sometime soon for him. Investigation continues. Until next week.